We'll start with a list of questions. Question number 5 has been withdrawn. I call Pam Cameron.
With permission, Madam Deputy Speaker, I will respond to questions 1 and 2 together. I'm committed to implementing the Police Remuneration Review Body's recommendations in respect of the 2025 Police Pay Award as soon as is possible. As members are aware, public sector pay awards must meet the affordability test before they can be implemented. I've been consistent in advocating for police officer pay to be placed on an equal footing with other public sector workers, and as a result of those representations was pleased to secure additional provisions from additional provisional allocations from the Executive, specifically police officer pay, in October on the same basis as health. However, even with this additional funding, the PSNI remain unable to confirm affordability for the pay award at this time. I'm fully aware of the commitment given by the Health Minister that health workers can expect payment of their award in February 2026. The consequence is that funding will be deducted from the health budget in the next financial year. That will no doubt have an impact in future years, and while I'm keen to ensure that police officers are treated on a par with other public sector workers, such decisions have wide-ranging implications for justice delivery. I will continue to work with the Chief Constable to explore options to allow PSNI to demonstrate affordability for the pay review body recommendations. I can assure the Chamber that the successful implementation of the Police Officer Pay Award remains a priority for me as Justice Minister, and I'm confident that the award will be realised by the end of this year.
Call Pam Cameron for supplementary.
Thank you, Principal Deputy Speaker. I thank the Minister for her answers so far, and I do wish her well in ensuring that police officers do get their well-deserved pay in the very near future. The Minister's on record last week in the media referring to the PSNI being unable to take industrial action, and that doesn't mean the police should be at the end of the queue when it comes to funding, and I agree with the Minister wholeheartedly on that statement. Minister, should the 1,600 police support staff decide to strike, has the Minister made an assessment on the impact that this would have on frontline policing functions?
Minister.
I'm sorry, I didn't catch the full part of the question, but I think you were referring to the police staff potentially going on strike, and of course the rationale for doing so is not to do with pay. Their pay has already been realised in year. The issue there is to do with settlement of the claims around the breach, the data breach. However, I would urge people, as I have done in the past, when there have been disputes either with staff or indeed with any other sector, not to withdraw their services, not to go on strike, but to work with me so we can actually find the resources available to make those payments. I believe it is important that the police are properly resourced. That includes making their pay, and that's why I set aside money at the beginning of the year when I was doing my allocations to allow for pay. However, the pay review body came back with a significantly higher allocation than expected, which left us with something of a gap to fill. Chief Constable and I have both been working really hard to look at ways that we can do that, and both between the department and PSNI and some of the savings that we're trying to make. I believe that I'm pretty confident we will be able to do that in year, and I think that's a better place to be in than entering into next year with an overspend and then essentially having that trickle on in future years.
Trevor Clark, please.
Principal Deputy Speaker, and can I thank the Minister for the answers thus far. Indeed, I share her optimism in terms of the pay settlement for police, and I hope we're both right in sharing that optimism. However, my question was much wider. It was the whole police funding, and we all know about the pressures that policing is facing in a minute. So are you as optimistic that something can be done to resolve some of those outstanding issues? In particular, I'm thinking of some of those big ticket items that we're talking about that's been in the media most recently.
Minister.
Well, in terms of the funding for justice generally, you will be aware that I have said on many occasions that we have seen an increase which is well below inflation. In fact, if we had only matched inflation over the last 10 years, we would have around 225 million additional in justice compared with what we have at the moment, which would be a game changer when it comes even to things like injury to feelings, like pensions issues, holiday pay, and indeed the data breach. So those are things that perhaps at a better time we could have absorbed, but we're not in a position to do that now. I continue to engage with the Department of Finance and with the Executive more widely, as well as with the NIO and with Treasury, because in addition to those issues to which we're already appraised, there is also the issue of legacy. and the cost of policing and the pressure on the justice system more widely coming down the tracks as a result of new legislation. We need to work out a sustainable model going forward that allows us to have a police service that is properly resourced for its primary task, but that at the same time is not eating up the entire justice budget, not allowing us to have courts, prisons and all of the other faculties that we need to provide. If I may, with your indulgence, Madam Deputy Speaker, correct something that I said to Mr Clark last week in the course of a question for the record. He had asked an issue regarding the release of an individual on pre-release testing. I had said that person had been time served on their tariff. They were not in fact time served, they were approaching that point, which is why their pre-release testing had been started. So apologies to the House if anyone was misled by what I said.
Thank you. I call Alan Chambers.
Principal Deputy Speaker, given pay issues may have a negative effect on police morale and possibly police recruitment, can the Minister give her assessment on whether reaching 7,000 police officers by 2027 will be achieved?
Well, undoubtedly, pay will have an impact on morale. There's no question about that. However, as I've said, there are other things that will also impact on morale in the PSNI, not just the amount of pay and the speed with which people get their uplift. The contractual pay arrangements have already been implemented, so I have split those because those are unavoidable. I have split those from the PRRB recommendations so that officers now get their contractual uplift automatically each October. So that will have been received and hopefully go some way to trying to ease the pressure on individual officers. What I want to see, however, is two things. I want to see the pay realised in year for the officers. I want it in their pockets as quickly as we can make that happen. And secondly, I want to put the wider system, including the PSNI, on a sustainable footing. That means executive needing to commit, as we come up on our 3-year budget, to what has already been indicated to me will be a priority, and that is the recovery plan. And we need that to be written into the budget for next year. But far be it from me to speak on behalf of the Department of Finance and the Finance Minister when it comes to making those allocations. He has indicated so far to me that that is his intention, and I think given that it meets the value for money criteria, it would make sense for us to do so. And to date, when he has made those promises, he has stood over them, so I can only rely on that.
I call Matthew O'Toole for a supplement.
Thank you, Mr. Speaker. Minister, I'm sure most people in this House would agree with your broad position, the position of other ministers and indeed the Chief Constable, that the Treasury should be meeting the reserve claim around the data breach. However, if we assume the worst from the Treasury, which is probably a good position for us to take, what planning is actually happening between you and the Finance Minister for a plan B?
Well, the first thing to say is that we don't know when this will crystallise. So obviously our preference would be to settle this as soon as is possible, but we don't know whether it will crystallise in this year or next year. And it's important that we don't set aside money this year and hold it until the last minute, because we then end up returning it to Treasury or having to negotiate with them over a budget exchange scheme, which often they're not willing to do at executive level anyway. So we are looking at a number of other options. We've been looking at, for example, is there an option to be able to convert some capital into revenue that would allow us to pay a one-off sum. We're also looking at other options we have to negotiate with Treasury in terms of how we would pay back any call on the reserve. So there are a number of things that are there, but at the end of the day, the Executive will have to look at its overall budget next year, deduct any overspends that we have projected at the end of this year that are still in place at the end of the year, then look at the other pressures that we have and decide where we allocate money. And I will be one minister at the table making the case for this being a priority, but it will require all ministers around the table to agree for that to happen.
Thank you, Minister. I call Paul Frew.
Speaker, question number 3.
Delivery of the Child Protection Disclosure Scheme is an operational matter for the Police Service of Northern Ireland. The scheme makes information to be disclosed to members of the public where it is necessary to protect children or a child from serious harm. This information may be requested by any member of the public and will be disclosed by the police where it is appropriate to do so. My department is responsible for the overarching legal framework. I note that the disclosure scheme is in line with the requirements of Article 50 of the Criminal Justice Northern Ireland Order 2008 and with statutory guidance which my department has published in accordance with that legislation. These public protection related matters are kept under review. Notwithstanding that, it is for PSNI to run the disclosure scheme. I still want to reiterate the message that I've given before. If anyone is concerned about potential harm to a child or children, it is incumbent that in the first instance they contact the police.
Paul Frew for supplementary.
Deputy Speaker, and the Minister has failed to answer my question, even though she had time to get the data in which I seek. And that does nothing to assuage my concerns that the Department of Justice and indeed the PSNI are refusing to promote the Child Protection Disclosure Scheme, meaning that parents are the last to know if there is a risk to their child. Will the Minister commit and inform this House of her plans in the future to promote the Child Protection Disclosure Scheme so that parents will not be the last to know?
Thank you. Minister.
Well, the first thing to say is that the data is not held by my department, and there is already an excellent ruling from the Speaker that when it comes to operational PSNI matters, I'm not required to seek that data or to present it here as though it were my own. So that's the first thing to say in terms of points of order on this. The second thing to say is that I think possibly with the sole exception of the member who asked the question, been one of the few MLAs who has repeatedly in this chamber, when others have asked for disclosure of the names and addresses of all sex offenders, raised the issue of these schemes, these disclosure schemes, the fact that they are available and that the fact that the public can use them, that the PSNI have both a right to tell but also there is a right to ask for the public. Now, I don't have a budget to be able to promote the scheme. If the PSNI believe that the scheme is being underutilised, they can of course choose to prioritise some of their resources. But given what we've just discussed in terms of the last question, I think I have made every effort throughout the last 18 months to make people aware of the scheme, to promote the scheme, and I would encourage other MLAs to do so as well, because I think the scheme works well in terms of public protection.
Sean Mulholland for a supplementary.
Thank you, Madam Principal Deputy Speaker, and thank you, Minister. Minister, can you outline to us what further steps you're taking to strengthen the statutory sex offender notification requirements?
Well, there are a number of opportunities provided by Home Office ministers so that we can further strengthen and streamline the current sex offender notification requirements by extending provisions proposed within the Crime and Policing Bill. As members will appreciate, providing for a consistent UK-wide approach to sex offender risk management, I think, is paramount to supporting wider public protection. I have secured legislative consent of the Assembly for the greater part of the proposed provisions, for which I'm very grateful, and I intend to bring forward a further LCM early in the new year to enable introduction of some further provisions in Northern Ireland. That includes, for example, the need to notify a new name no less than 7 days in advance of it being used, the requirement to notify at least 12 hours in advance before entering qualifying premises where children are present, to seek approval of the police to apply for certain identity replacement documents if those are in a new name, and of course we are now looking at the list of prescribed police stations where an offender must notify instead of the need to amend that by way of statutory rule, and the ability for notification to be given virtually in certain circumstances but only where certain conditions are met. All of that with a focus on trying to streamline how we manage sex offenders, but also how we ensure that the public are fully protected. We're also looking at the ability of a police officer to consider whether a relevant offender should remain subject to indefinite notification requirements without the need for an application to be made from the relevant offender, and also the ability for an application for a warrant for power of entry and search of an offender's home to be made by a court officer of at least the rank of inspector. So there is considerable work ongoing in this space, because I think we would all agree that we want our children, but indeed the wider society, to be properly protected from predators.
Thank you. I call Philip Brett.
Deputy Speaker, question number 4.
With your permission, Madam Deputy Speaker, I want to answer questions 4 and 13 together. Restorative justice is a well-established practice in Northern Ireland, both within the formal youth justice system and through community-based initiatives. It aims to address the harm and/or trauma caused by crime by involving victim, perpetrator and community, supporting dialogue to repair the harm caused and to promote healing. It also emphasises the importance of supported rehabilitation in order to reduce the risk of further offending. Restorative justice has been at the core of the youth justice system here for over 2 decades, and a range of independent reports and Virginia inspections have recognised those benefits. Learning from the youth conferencing process is being used to develop and extend the use of restorative approaches in the adult justice system. The two current accredited community organisations have played an important role in promoting community safety, repairing relationships and reducing antisocial behaviour, working in partnership with justice partners to deliver restorative approaches to harm which does not meet the criminal threshold. They've also played a key role in the development of the new accreditation arrangements as part of the Restorative Working Group. My department's been delivering on the commitments in the Adult Restorative Justice Strategy since its launch in 2022, including publication of the revised Restorative Justice Protocol in 2023, a key aspect of which is the development of new practice standards and accreditation framework to govern the delivery of future restorative work. That framework, developed by my department and the interim protocol lead, was published on the 17th of October 2025, aligned with the application process launch for those wishing to become accredited. That application window will be open for 6 weeks, closing on Friday the 28th of November. Once applications close, the protocol lead and an independent suitability panel will assess and make recommendations on the appropriate level of accreditation. A register of accredited organisations and practitioners will then be published on the departmental website early in 2026.
Call Philip Pratt for supplement.
The Minister for that. In North Belfast, we're blessed to have Northern Ireland Alternatives headquartered in our constituency, and under the leadership of Debbie Waters, OBE, the work right across Northern Ireland has been vital. Will the Minister commit to continuing to work with Northern Ireland Alternatives and CRJ to ensure that we continue to deliver this important role throughout Northern Ireland?
Minister.
Well, what we're intending to do is to create essentially a pyramid of access for restorative justice. So at the top of that, with the highest qualified and most experienced providers, they would be dealing with the most sensitive cases where restorative justice may be appropriate. At the bottom of that tier will be a much wider group, much higher numbers, who will be dealing with more community-based restorative interventions rather than justice referrals. And in between then there will be stages of accreditation for people to be able to also, I suppose, to be able to develop themselves personally in their chosen way. I'm committed to continuing to work with all of those who go through the accreditation process, who continue to engage with the formal justice system, and who do so with integrity, but also with connections in the community and the ability to engage people on the ground in a way that perhaps the formal justice system is not always fully able to do. Crucial for me is the ability to engage with the PSNI, with the courts, with probation and others to ensure that the decisions that are made around restorative justice bring about changes in behaviour, but also leave victims feeling that they have got the outcome that they would wish and deserve.
I call Andrew McMurray for supplementary.
Thank you, Principal Deputy Speaker, and thank you, Minister. Can the Minister explain how this work will be supported by the new restorative hub that your department is establishing with the Probation Board?
Well, the new restorative hub will be integral to the delivery of adult restorative justice services. The benefits of the hub are that practitioners can co-facilitate their referrals to gather experience, participate in group training and professional supervision, and contribute to a monthly community of practice. So it's actually about allowing all of those who work in the sector to share their experience and skills, and hopefully to find some economies of scale when it comes to training and development. All of that is critical to ensure consistent and high quality delivery of restorative justice. The hub was going to be managed by the independent referrals body, which will sit within Probation Board's victim unit, because this has to be victim-centred, as a well-established and neutral statutory organisation with expertise who can deliver those services. I think it's really important in terms of the work that probation do in terms of perpetrator-victim conferencing, that they will be able to bring that to bear and work with others in the community who may be able to become more engaged in the formal justice process as a result.
Thank you. I call Doug Beattie for supplementary.
Thank you, Principal Deputy Speaker, and thank you, Minister, for your answers so far. I think restorative justice is one of those areas which I'm really glad we're talking about. I think it's incredibly important. But I just ask the Minister if she will look at adult restorative justice forming part of the sentencing framework in the new sentencing bill.
Well, adult restorative justice is already allowed for within the policy and the statement that we have already made. So we already have launched a strategy and an action plan. So it's already being dealt with. In terms of it being put on a statutory footing, it's very hard to do that because restorative practice can take a multiplicity of different forms, and I think to try and prescribe that in legislation would be difficult. However, it is part of our overall strategy for the delivery of justice. It is part of our overall strategy for engaging particularly with levels of satisfaction of victims within the justice system, and also also in terms of our overall reoffending and assistance strategy. So I think from my perspective, I think it's well covered in terms of the strategy we already have in place and the considerable work that has been done through the working group to deliver the new structures that hopefully will allow it now to take on a new level and more momentum and dynamism than in the past.
Deirdre Hargey for supplement.
Much, Minister. You'd said there about the new pyramid system of accreditation, and I suppose at the committee we heard from Restorative Justice and Alternatives some concerns about level 1, and particularly then the ethos of adhering to the peace process, but then also around working with the PSNI, etc. And they raised concerns there may be gaps. Can you assure us that that wouldn't be the case?
Well, we're fairly confident, given the work that has been done and which both Community Restorative Justice Ireland and Alternatives have been involved in as part of the working group, that those areas are covered. When I talk about the different levels, I mean, to be clear, some of the people we're talking about at the top of that pyramid, where you will have very few practitioners, will be in cases, for example, of rape or murder. So very serious offences, but where there may be some restorative practice necessary. For example, we have been approached and we have examples of victims who want to sit down with the perpetrator and have a conversation with them, and restorative justice can allow them to do that in a way that is meaningful and respectful and victim-centred. So that would be at the very apex, if you like, of difficulty. Then there would be stuff that isn't justice, but it's actually more about restorative practice in terms of community dispute resolution and other things, so it wouldn't have reached that. And between that, there will be a whole scale of either the kind of diversionary conferences with young people, the work that probation does with offenders post the point where they've been convicted and so on. And I think there will be opportunities for organisations to upskill and to be able to go through those layers of accreditation. Some of the practitioners that we have in Northern Ireland are amongst the most skilled that you'll find anywhere in these islands. I believe that we should use that resource to best effect.
Thank you, Minister. Question 5 has been withdrawn. I call Ciara Ferguson.
Principal Deputy Speaker, question 6.
Proceedings Act Northern Ireland 2021 have now been commenced. However, work to implement a few outstanding measures is still in train as follows. Section 27, which makes provision for my department to take regulations in relation to protective measures for victims of abuse, in particular for domestic abuse protection notices and orders, or DAPNs and DAPOs as they're often referred to. I've already set out the challenges that my department has encountered in trying to develop a DAPN and DAPO model for Northern Ireland that will enhance the protections available to victims of domestic abuse whilst being operationally viable and affordable. My officials are continuing to work with partners, including PSNI, to resolve the challenges with a view to launching a DAP and DAPO pilot in the next financial year. The model will take into consideration the specific Northern Ireland context, including operational capacity, cost and, most importantly, the needs of victims. Fact-finding visits to pilot areas in Croydon and Greater Manchester have been valuable in informing policy development. The aim is to agree a preferred pilot model with delivery partners by the end of this financial year. If the member would like to write to me, there are, I think, about 4 other sections which still have to be commenced in terms of delivery, but I think it would be better to put those in writing rather than prevail on the patience of the Chair.
Ciara Ferguson for supplementary.
Can I thank the Minister for your answer thus far? Minister, is there a timeline or further information around when the prohibition of cross-examination in persons in civil and family proceedings, and likewise what work has been done to date regarding CGI's recommendation for better to develop the role of specialist domestic abuse prosecutors?
Minister.
Well, I'm glad that I don't have to write to you, because that was the next part of my question and I just thought it was too long as I was working my way through it. So first of all, work is continuing in relation to Section 32, which is the one placing a requirement on the Department to publish the statement setting out information about the level of participation by personnel and staff in domestic abuse training. The Department has already published 2 training statements in line with the requirement, and that work is well advanced to finalise now the 3rd report on that, and that is one way that we can actually increase expertise. You will appreciate that not everyone in that cohort will be an expert provider, but it is important that all first responders and those who are in contact with people in the system have to have a basic level of knowledge. We're also continuing in respect of sections 36 and 38, which provide for the prohibition of cross-examination in person and family and civil proceedings, and section 39, which requires court rules to make specific provisions for special measures for victims of specified offences in civil proceedings. Our focus in relation to those provisions continues to be on implementation in family proceedings as this will have the greatest impact for victims. The provision relating to court rules and special measures for victims of domestic abuse in Section 37 has already been implemented, and the drafting of the secondary legislation required in support of the prohibition on cross-examination in person provision is underway, subject to emerging priorities and securing the necessary funding for the court-appointed legal representatives. The aim is to commence that provision during this business year.
Thank you, Minister. I call Nick Matheson for a supplementary.
Thank you, Principal Deputy Speaker, and I thank the Minister for that detailed update. Could you provide an update also on the latest round of funding under the Domestic and Sexual Abuse Small Grant Scheme?
Yes, projects which offer vital support to victims and survivors of domestic and sexual abuse have recently received funding from my department and the Department of Health. A total of £259,091 has been allocated across 10 organisations for the scheme in 25-26. That will enable them to deliver a range of services, including trauma-informed counselling, crisis de-escalation therapy and one-to-one legal advice clinics. Those interventions play a very important role in helping individuals recognise harmful behaviours, seek support at an early stage and navigate what can often be a very challenging and complex process. The voluntary and community sector continues to demonstrate innovation and dedication when it comes to working with victims and survivors, and so I believe it is important that we continue to fund them and to try and ensure that they're able to bring that expertise to bear. The Domestic and Sexual Abuse Small Grant Scheme is a key initiative under the jointly led Domestic and Sexual Abuse Strategy. It supports organisations represented on the Domestic and Sexual Abuse Expert Reference Group and the 5 Domestic and Sexual Violence and Abuse Partnerships. This is the second round of awards that have been made, so the total funding allocated under the scheme to date is £568,718.
Thank you, Minister. I call Gary Middleton.
Madam Deputy Speaker.
I welcome the publication of the Drug-Related Intimidation in Northern Ireland report commissioned by the Executive Programme on Paramilitarism and Organised Crime and delivered by the Public Health Agency, and was pleased to be at the launch with Minister Nesbitt. The report shines a light on and recognises the seriousness and impact that drug-related intimidation has on individuals, families and communities right across Northern Ireland. It provides a valuable evidence base and highlights the complexity of the challenges involved, including the role of organised crime, paramilitary influence and the vulnerabilities of those affected. It also demonstrates the widespread and pervasive impact of the harm caused by drug-related intimidation. Nearly 40% of the general population are aware of suspected or real drug-related intimidation happening in the community, and 1 in 8 reported direct experience in the last 3 years, either to themselves, someone known to them or a member of their family. There are a number of measures which the Department is already progressing which will help address the findings of the report. They include bringing forward new legislation and introducing new offences such as participating in and directing criminal activities of an organised crime group, new legislation in relation to addressing the vulnerabilities created by cuckooing and child criminal exploitation. Work is also underway to improve child referrals to the National Referral Mechanism in relation to child criminal exploitation, the work of the Speeding Up Justice programme, which is focused on reducing delay, and undertaking the sentencing review that I hope to introduce later this year. However, there is much more to do, and over the coming months my officials will engage with the Executive Programme on Paramilitarism and Organised Crime team and wider criminal justice partners to consider the recommendations in more detail. I'd also note the outworkings of this report are wider than just justice, and I'm committed to working with all sectors, including health, housing, education and community organisations, to build safer, more resilient communities.
Call Gary Middleton for supplementary.
Madam Principal Deputy Speaker, can I thank the Minister for her response? And the Minister, you have highlighted that the drug-related intimidation is not only an issue for policing or certainly for justice. So can you then, Minister, outline how you plan to work with other ministers? You've mentioned that in your answer. How you plan to work with other ministers to provide a response to the PHA findings?
I think first and foremost, even the report itself is a collaboration between 2 departments. The Executive Programme now has a Ministerial Advisory Panel, and every Executive Minister is invited to participate in that, so they will get direct briefings that will allow them to feed into the issues that are being raised. All Ministers were also invited to go to the launch of that, but I realise that not all Ministers will be available, and people will prioritise. But I do think it's important as an Executive that we see that there are societal elements of this that need to be dealt with, there are criminal elements of this that need to be dealt with, And then there are the wider issues around mental health and addiction that need to be dealt with in a therapeutic environment, as opposed just simply through a criminal justice lens. We know that issues around health, housing, and other issues are incredibly strained when people find themselves either being extorted because of drugs or feeling and struggling to be able to maintain their payments to their dealer. And unfortunately, the intimidation and the coercive control that people exert in those circumstances is bleak. It can be life-changing, but it is certainly life-destroying for many people, and I think it's important as an executive that we work collectively to try and avoid it.
Thank you, Minister. We must move on now to topical questions. So that's the end of the list of questions, and I call Patsy McGlone.
Minister, would you launch an independent inquiry into how 40,000 bullets have reportedly gone missing from a PSNI training centre in Antrim?
Madam Deputy Speaker, I first of all share the concerns that many in this House will have at the reports that they have read over the weekend. My officials were engaging intensively with colleagues in PSNI, and I've spoken with the Chief Constable myself in terms of seeking clarity. I am somewhat constrained in terms of what I can say because we are midway through what is an active police investigation. I wouldn't want anything I said in this chamber to jeopardise any future lines of inquiry that they might have. But it's fair to say that it is incredibly serious. It is being treated so by the Chief Constable, and I think for now that is probably as much as I want to put on the record, other than to say that I have conveyed to him obviously my concerns regarding the potential threat this represents to public safety.
Patsy McGlone for supplementary.
Thank you, Minister. I'm sure everyone in the chamber shares the concerns that 40,000 bullets should go missing. In the event of, would you support an independent inquiry into how this indeed happened?
Again, I don't want to be specific about the number of rounds of ammunition. I don't think we can be specific at this point in time, so I don't think that's helpful because there have been conflicting reports around that. And I don't want to prejudge the outcome of a criminal investigation by launching a public inquiry because I think that's putting the cart before the horse. I think the first thing we need to do is allow the PSNI to conclude the criminal investigation which is currently underway. And if at that stage there are wider questions which need to be asked, there will be an opportunity for those on the policing board and for myself to drill down into those and decide the best means of ascertaining the full facts of the case. But for now, I think it's important to let justice take its course.
I call Connie Egan, please.
Thank you, Minister. Can I please ask for your assessment of reports that members of the Criminal Bar Association have voted to escalate the withdrawal of service?
I thank the member for the question. My officials have been engaging intensively over this weekend to clarify the specific actions CBA membership plan to take with immediate effect this week. The Bar Council confirmed the definition and scope of the planned action late yesterday afternoon. There has been a lack of clarity both within the criminal bar and between the bar and ourselves over this matter over the weekend, which is incredibly concerning. I understand that a number of CBA members were planning to withdraw from all Crown Court cases with effect today, which only serves to demonstrate the vulnerability of those who are turning up at court to face a lottery as to whether or not a barrister will take their case. That such a course of action was even being considered, I think, is profoundly concerning. However, I had a positive meeting with both arms of the profession last week. I think that makes this all the more depressing because I reaffirmed my commitment to bringing forward enhanced legal aid fees and ongoing engagement. Officials in the department and Judge Burgess have been working tirelessly to bring the previous partial withdrawal of services by the CBA to an end. And since they clarified why they had a partial withdrawal of service, those conditions essentially have been met. I understand that over the weekend, for the second time in 3 months, the entire executive committee of the CBA have resigned. So, look, I am not going to get into the internal machinations of politics within the criminal bar. There are enough politics in this place to keep me fully occupied. What I want to do is ensure that the criminal bar continue to take instructions in complex cases, move away from the partial withdrawal of service that we currently have, and crucially, that victims, particularly those most vulnerable victims, are able to access justice in a timely fashion. I'm committed to doing that. I believe the people I spoke with last week were genuine in their commitment to do that, and I just hope that we're able to proceed with that by the end of the month as anticipated.
Connie Egan for supplementary.
Thank you, Minister. Could you please outline the impact that the ongoing withdrawal of service has had on victims, witnesses and the wider justice system?
Well, obviously, any additional delay is impactful on the justice system, particularly on victims, witnesses and defendants, many of whom will be being held in remand, and the impact then is not going on to our prison system. 132 Crown Court cases were listed to be heard across the Crown Court today. In light of the emerging decision late yesterday afternoon, they have not been impacted by withdrawal of service. The specific actions taken today have varied, so it seems to be at the moment that it's only new cases that are not being taken in that action today, but that clearly will have an impact down the line. And the specific actions being taken by CBA members have varied somewhat since the withdrawal of service commenced last December. Since March, members have refused to take new instructions in murder and serious sex offence cases, but as I say, that has now been extended, I believe, with effect from today to all Crown Court cases. That puts more stress on the criminal justice system and court business. It is wasteful of scarce resources, and I think it is time that the Criminal Bar Association made clear what their intentions are. I have been able to work with the Solicitors Criminal Bar, with the Law Society and indeed with the Bar Council more generally in terms of trying to address some of the genuine issues that they have. I'm willing to do that with the Criminal Bar, but there has to be some sense of putting victims back at the heart of the discussions that we're having and trying to ensure that we can do that while still providing the service for which people rightly seek to be paid.
Thank you. I call Donny Baker.
Thank the Minister for her answer so far. Minister, during the public consultation on the new youth custody and supervision orders, views were openly split between those in favour of setting the minimum duration and those against. Is setting a minimum duration in keeping with children's rights?
Well, I'm aware of the discussions that have been taking place on this, and you're aware of the position that the Department has taken, and that reflects very much my own view. I think there is a balance to be struck in all of these things, and I'll be happy, obviously, to engage with the committee as you move forward in terms of the way to handle this. I think it is important that there is clarity around what these orders will look like. That's one of the things we're trying to do by replacing multiplicity of orders and conditions with something that's much more streamlined and easily understood by the young people themselves. I think knowing when the order will end is also quite important for young people to know that there is a finite timeline of engagement. But I think that I understand certainly the arguments being made about the minimum length of the order. I suppose the crux of this is to have long enough to be able to engage with and build trust with the young person involved and their family to actually be able to effect a difference. Because if the orders are too short, a bit like sentencing, if they're too short, it doesn't allow us to do the rehabilitation work we would like to do. We'd be better off in the community working through those things.
Donny Baker for supplementary.
Thank you, Minister. What steps is the Department going to take to monitor and assess if the new youth custody and supervision orders is being used as a measure of last resort?
Well, I think there are a number of things we can do. We can look, for example, at the practice that's already happening within the youth justice sector. There are very few young people now held in a custodial environment, other than those who either choose not to make their bail conditions, which some do because they don't feel safe returning to the community, or those who have committed potentially very serious offences that would require a public protection response. And I think that commitment has been shown in terms of making sure that we try to do the earliest possible intervention. You'll be aware of the work that Youth Justice does in terms of, for example, providing supplementary work in the CAM scheme for young people at risk of offending, and actually working with those who are right on the boundary between getting themselves into quite serious trouble or not. And I think that is the measure of the commitment of the people who work in Youth Justice Agency, to ensure that insofar as we can, we divert young people away from the criminal justice sector and from criminality, crucially, because what we're trying to do is protect those young people from becoming involved in activities that will mark them potentially for the rest of their lives, because we know that people will graduate through the system, and that is not good for them, it's not good for their community, and it's in all of our interest to support that.
Thank you. I call Alan Robinson.
Deputy Speaker, could the Justice Minister outline any plans to review the explosives Fireworks Regulations NI 2002?
Well, Madam Deputy Speaker, I'm somewhat concerned that I might end up stealing the thunder of the members immediately to my right here, because I think there's a debate about this next week, if I start announcing what my intentions are as of today. Our fireworks legislation in Northern Ireland is some of the most robust in these islands for, I think, rather obvious purposes, and there are reasons why we have concerns. Some people love fireworks, some people hate them. As an animal owner myself, as a dog owner, I understand the stress that it can cause, particularly to animals, and I understand that. But we do have very robust legislation in place. I also have limited resources, and I would have to take those resources away from something else to do this piece of work. And so I'm not entirely sure that that would be the appropriate way forward. However, other members have mentioned in question time today the sentencing review, which we're hoping to launch in the autumn. And there may be something around penalties and enforcement that we may be able to do as part of that sentencing review, which would mean that those who breach the currently quite robust regulations that we have would then be able to be held to account, perhaps in a way that is more of a deterrent.
Thank you, Principal Deputy Speaker, and I thank the Minister for that response. Just to expand upon it, we hear more and more every year at this time of year of family pets that are facing extreme stress as a result of fireworks. Would you consider the introduction of low noise fireworks?
Well, the member is almost channeling what I was thinking in my head that I hadn't managed to say in the original answer. I always, when I'm writing to people about this issue, I always promote the use of low noise fireworks. There are also the opportunities to do some pretty amazing displays using drones and not using fireworks at all. The number of organised fireworks displays has actually dropped dramatically since the 70s and 80s because the cost of fireworks has become exponentially much greater. So there is a balance to be struck, and I understand as I say, the concerns that people have in terms of pets. We spent quite a bit of time, both myself and the Dairy Minister, over the Halloween period, for example, sharing advice and guidance to animal owners as to how to ensure that they could do their best to keep their pets safe. But obviously, my preference, personally, as well as for animals, would be that there were low noise fireworks. I do think that I think fireworks noise is a problem. I think we can't be prescriptive though, because not all low noise fireworks would be suitable for every occasion. But I do think that the reduction in the number of fireworks licences being granted is indicative of the fact that many people are moving to other kinds of displays that are celebratory to avoid the use of fireworks or over-reliance on it.
Thank you, Minister. I call John Stewart.
Speaker, and the previous member did steal my thunder, but I do think, Minister, that it is a very topical point. For weeks leading up to Halloween, we know this, that vulnerable elderly residents and unfortunately thousands of pets have to suffer the noise that goes with this. And we heard of the tragedy of a dog a few weeks ago who died as a result of this. I know that you're not minded to review the regulations at this stage, and you've outlined why. Has you had any engagement though with senior police officers about how they could better interpret that and how they could use their resources to tackle those who routinely misuse fireworks?
It's one of the things in terms of sentencing that I think maybe more robust sentencing for breaches of the licensing would actually be quite helpful in terms of making it clear that it won't be just a fine in terms of what is a relatively expensive business, but that there will be some consequences for that. So that's one element of it. The other element, I suppose, is about investigation. The most annoying situation is not actually organised fireworks displays that are well advertised and well notified, and we can often put notification requirements on when people purchase fireworks. It's individual bangers going off at random times of the day and night, and it is traumatic for many people. It's frightening for older people, those, for example, who, because of their history, have fear of bangs and loud noises and so on. Young people with autism and neurodiverse people can find it quite distressing, as can animals. So there is a wider issue, and I think it is about trying to say, how do we bring a balance to this so that those who enjoy fireworks, and I confess I enjoy a good fireworks display as much as anyone else, but those of us who enjoy fireworks are able to do so in a way that is safe and doesn't overly impinge on the rights of those who just want a quiet night at home without random bangers going off in the neighbourhood.
Speaker, and I thank the Minister for her answer. You talk, Minister, about the fact that the regulations are some of the most robust anywhere around, but they are over 20 years old, and fireworks have moved on, both in the strength of them and the noise of them, and some are approaching the likes of explosives, so maybe there is something that could be looked at that. Is there also an opportunity, maybe a pilot project somewhere with PCSPs to look at how better we can tackle it on a local level, potentially?
Minister, you have 70 seconds.
Certainly,
Exactly.
anywhere where there is a particular local issue that needs to be addressed, I would encourage PCSPs to engage and try to find solutions, because I'm always open to solutions if people can come to me with those. Unfortunately, more often than not, I get problems.